I don't know if we've saved the best for last, but he'd have my vote for the best for last. Major Tom Fleener, I had the good fortune to speak with him for the first time about 3 weeks ago. I just called him up on the phone in connection with some other work that I'm doing. As we were ending our conversation, he said, well, if you ever need a speaker, and that's about as far as he got. We made the arrangements, and he offered to come out and be here today to speak with us. Major Fleener is a federal public defender from the state of Wyoming, a neighbor of ours, but he's also an Army reservist, and he's been called up to active duty to serve in the Office of Defense Counsel as part of the Office of Military Commissions. The military lawyers that are providing detailed military counsel support for the Guantanamo detainees that are charged with crimes. Under the prior scheme that was struck down by the Supreme Court, he was assigned to represent one of the detainees. That individual, I'll let him talk about that, but that individual has not as yet been recharged, to my knowledge. Well, he hadn't as of yesterday anyway. But I would ask you to give a good, warm Montana welcome to Major Tom Fleener.
I guess I'll start by putting that on my uniform. I'll start, I guess, by saying what all the speakers have said, which is this is a great opportunity. It's wonderful to be able to come here and speak to people from various locations and various walks of life. And you guys have treated us wonderfully, and I know I can speak for especially the out-of-towners, Greg, and some of the other folks who've flown in, that we certainly appreciate the hospitality, and we couldn't have been treated better, so thank you. And I also appreciate the student organizations that helped fund this and set this up. I want to give you guys a disclaimer first, and I gave it when I was on a rant earlier about the fact that while I'm here in my official capacity in this particular case is as a military attorney assigned to represent Guantanamo Bay detainees. I don't speak for the Department of Defense, and most of my opinions are actually contrary to the official positions of the Department of Defense. But we're defense attorneys, and defense attorneys do what you can do in a representational or quasi-representational capacity. And one thing I will say is that the Department of Defense has generally been very, very supportive in recognizing the difficult position that defense attorneys are in, uniformed defense lawyers are in, while we're trying to advocate on behalf of a particular client in Guantanamo Bay, when essentially the accuser or the prosecutor of this entire process is the Secretary of Defense to the President and just very high-ranking folks. They recognize that, and they have been very accommodating regarding letting us come and do what we think we need to do to adequately represent a guy. I don't know whether it's it's just because they're being kind. I think it's certainly in the government's best interest to be able to point to military lawyers that are out trying to do what they can on behalf of a client. There's certainly downside to trying to shut us up. And so, maybe it's a cost-benefit analysis, and the decision is that it's better to have a few rogue lawyers going out and doing what they can to further what they believe is in the interest of their client versus quieting everybody up and driving on. But motivations aside, it certainly is a great opportunity. It's a privilege to be here. And I'm going to try to be fairly brief because Jim was good yesterday, and he covered all my crap. I had all these notes, and I just kept marking things off, and now I have nothing else to say. But I'm a trial lawyer, and that's the beautiful thing. We can talk all day long about nothing. It's what we bring to the table. I try not to give. I try not to use statistics that I haven't been able to actually verify by reading a document myself, just because I'm I don't trust everything that I hear. I certainly want to see it first. With that being said, one of the more interesting things that haven't had a chance to verify, though it does come from a fairly decent source, is that the youngest person that was ever in Guantanamo Bay was 10, and the oldest was 94. And when you think about that in terms of the comments that various officials have made about the worst of the worst, plucking combatants from the battlefield, it sort of puts things into context a little bit. And again, I don't have those. I haven't seen that with my own eyes, but it does come from a very, very good source. So when you're thinking about Guantanamo Bay and you're thinking about the solution of how to handle the judicial or the justice system aspect to the war on terror, if there should be trials in Guantanamo Bay, it's important to understand who you're actually dealing with. And Nancy did a wonderful job earlier today sort of explaining who the people were in Guantanamo Bay and trying to put, I guess, some meat on the bones. I throw that out there just for whatever it's worth. Earlier today, someone asked where people should be tried. Should they be held? Where should they be held and where should they be tried? And I have another statistic which is actually I have verified. And the question is, are we in this war paradigm where you can't use regular law enforcement models, you can't use Article III courts to try these very, very dangerous terrorist suspects? That you have to create a system of laws and rules separate than from all the other systems that exist to try these special groups of folks. And I'd point out that since 9/11, there have been over 400 successful prosecutions in Article III courts for terrorism-related activities. And there have been 0 military commissions. And I don't want to say you should compare 400 to 0 and say you should try people in federal court, but you really should compare 400 to 0 and try people in federal court. We wouldn't be in a lot of the mess that we're in today regarding what you're going to do with folks in Guantanamo Bay. Are they going to be held forever without charges, or are they going to see their day in court? Had they just tried people in regularly constituted courts for the last 5 or 6 years. And unfortunately, we're right now back to this, essentially back where we were 5 years ago. I'm sorry, it's 400 to 1. We actually had one successful prosecution before a military commission, which I'll get to in a few minutes, and we can discuss whether it was successful or not. But again, I think it had hindsight being 20/20, of course. Had decisions been made differently, we may very well be in a different position as far as the entire detention, interrogation, and trial scheme than we are today. I really appreciate Department of Justice sending Greg out, and I had the opportunity to speak with him last night at length, and he said something which was just dead on. Well, I disagree with him certainly on some things, but one thing that Greg said to me yesterday, which was that that really it's the focus of all of the debate and the main legal issue should be the interrogation and detention policies post 9/11. And military commissions are we should just get a little, we should be an afterthought. The real issue is how can you hold people forever? Under what conditions can you hold them? What can you do to them? When do you let them go? What is the processes in place to determine whether someone should be held or whether someone should be released? Those are the real issues. Unfortunately, the military commissions aspect of it has grown really exponentially. And truth be told, there's been one military commission now 2 weeks ago, the David Hicks Military Commission, compared to the 800 or 900 people that have been held in Guantanamo Bay, the 400 folks that are still in Guantanamo Bay, and the Combat Status Review Tribunal, Administrative Review Board, Detainee Treatment Act appeals that are going to start working their way through the process. That's the vast majority. We may try 10, maybe the government says 50, 50 to 60. If I were a gambling man, I'd probably say somewhere in the neighborhood of maybe 20 of these folks will actually be tried before military commissions, yet they get a great amount of attention, which I think is unfortunate. I think what has happened with that, though, I mean, the reason why the military commissions has got so much legs is that the administration and others in Congress now they're using the military commission process as the fig leaf for the indefinite detention of people. That we have this trial system that we've set up. That's why we can hold people forever and ever and detain them and interrogate them and do what we need to do to them to protect our country and to protect Americans. So the military commission system has sort of taken on a life of its own, where it's not really a justice system anymore. It's more of an afterthought, which is used to justify the interrogation and detention policies that have existed for the last 5 years, coming up on 6 years now. And I want to talk about one principle, and then I'll get to some fact-specific issues with Guantanamo Bay and the military commissions, and discuss the actual premise of my talk, which is whether Guantanamo Bay military commissions can provide for fair trials. I guess the issue the concept I want to discuss briefly is this concept of conflation. And I think what the government has done is they have sort of conflated these two principles of detention and interrogation and meting out punishment for those who are responsible for 9/11 and other terrorist acts. And the theory is we need to detain, interrogate, and gather information, and we need to be able to hold those responsible for 9/11 and other terrorist-related activities, and sort of applying the same principles to those two very different concepts. I believe that as a military officer, as an American, I want the president to be able to protect us. I think that the commander-in-chief, one of his primary duties is to protect the country, and I want information to be gathered. I want intelligence to be gathered. I don't want to have to wait for another 9/11. That's, I think, the worst possible scenario. But at the same time, that doesn't mean that you have to then set up a justice system on the back end, and that the same rationale for detaining people are used to try folks on the back end. Detain people, gather information, debate how long you can keep them and under what conditions and whether the information is good or bad. Don't screw around with the rule of law on the back end and try to set up a justice system that doesn't comply with anything that Americans have ever recognized, and which has generally made us just suffer extraordinarily in the world's eyes. And I think, unfortunately, that's what we've done, is we have taken interrogation, detention, and trial and lumped it all together. And I would really like to see them pulled apart and discussed separately. So now I'll try to discuss them separately. And because understand, I think that the same rationale behind the president protecting us and gathering information and making America safe and stopping future terrorist attacks, that's the rationale behind the detention interrogation policies. We have a different duty as a country when you're setting up a justice system. And when you're setting up a justice system, you have an obligation to the rule of law. And unfortunately, I think we're forgetting our obligation to the rule of law. We're just trying to set up the justice system to make up for some of the shortcomings and justifications that exist on the detention interrogation side. I'm one of the few folks who've actually been down in Guantanamo Bay litigating before the military commission system. And Jim did a great job yesterday of discussing the Military Commissions Act. And real briefly, the military commission system, I jokingly refer to it. All this stuff would be funny if it wasn't so serious. I jokingly refer to the new one as Military Commissions 3.0. You had 1.0, which existed after the military commission, the President's Military Order of 2001, which, as Greg said, mirrored FDR's order in 1942. And then you had a system of rules and instructions that the Department of Defense drafted, and they tried to try 4 detainees through 2004. The detainee that I've been assigned to represent, Ali Hamza al-Bahlul of Yemen, was one of the original 4 that was scheduled to be tried back in 2004 under Military Commissions 1.0. That system looked really, really weird. Now, I wasn't there to see it. I was minding my own business in Wyoming as the simple country lawyer. But you had a system where they had a judge and a jury that were all wrapped up in the same body. So you had this panel of military men and women in theory, though there weren't any women down there, some line officers and a military lawyer, and they would all decide issues of law and fact together, which was similar to what happened in Quirin in Washington, D.C. during the Nazi saboteur trials in 1942. Unfortunately, it just looked really, really weird in 2006. And I guess I'm going to take a jab at Greg a little bit, which is, this is a point I'd like to make, which is that, when you hear the administration and some of the folks in justice talk about how, the Eisentrager principles of 1950 case in Germany and, the Quirin decisions of 1940, 42, and how we're now off. That's principle for what we're doing now, or precedent for what we're doing now, and the protections that we're offering people now are greater than the protections they're offering people in 1942, or a little bit better, or just similar. The problem is the rule of law has evolved. I mean, we've gone through the Brennan Court. I mean, the Geneva Conventions exist now. So when you're looking at how we're treating people in 2006 or 2007. You can't just draw a straight analogy to 1940 and say we did it in 1940, we can do it in 2007. And they recognized that before Military Commissions 1.0. That was a ridiculous looking system where no one, the media didn't understand, none of the lawyers understood what was going on. The presiding officer, who was the judge, who had a quasi-judicial, quasi-fact-finding role, didn't understand his roles. Certainly the jurors, the Military Commission panel members, had no idea what they were going to be getting into, because they were going to be deciding issues of law, which there's no reason for a submarine commander to decide issues of law. He's going to look to the lawyer and say, "Judge, what's the answer?" When the Hamdan District Court opinion came out, which was Judge Robertson's opinion back in 2004, which stopped the Military Commissions 1.0, the one thing the administration did, which was smart, is that they recognized that thing looked weird, and that they don't need it looking that weird anymore. They'd prefer to make it look somewhat like a normal court system looks. So they wrote Military Commission 2.0 during this hiatus between 04 and 05. They had some time to write new rules and set up a new structure. This new structure had a judge, sort of, and had a jury, sort of. Unfortunately, they were still bound by the President's military order of the President's military order of 1942, which became President Bush's military order of 2001. And in that military order of 2001, it said things like the military commission members shall decide all issues of law and fact. And rather than going back to the president and saying, "Sir, this looks terrible. We need to get a new president's military order." Decisions were made not to get the new president's military order, but just to have the Secretary of Defense try to tweak the system on his level. And he created this new military commission system, 2.0. 2.0 had a judge, kind of, a jury, kind of, but because they were still bound by the rules of the old president's, of the president's military order, the jury was still able to overrule the judge on decisions of law, and the instructions that were drafted after that just looked more and more ridiculous. I got mobilized as an Army reservist and invited to come play in Washington, D.C. and Guantanamo Bay starting in 2005. I'm one of the few folks who've actually been down there litigating in Military Commissions 2.0. They had 7 cases that were scheduled or at least started in 2006. My case was the only one of the original 4 that started up again. The other 3 original cases were on judicial stays or administrative stays. The Hamdan case is being looked at by then the Court of Appeals, and ultimately the Supreme Court. The Hicks case was, who's an Australian, was following sort of the same path. He had a stay from a district court judge waiting to hear what was going to happen in Hamdan. So they started 6 new cases, and then they brought Al-Bahlul's case up, started it before Military Commissions 2.0. I was mobilized. I spent several months in Guantanamo Bay in 2006. And I can only tell you that to those who are practitioners, lawyers in courts, it was a feeling of utter lawlessness. I was the first. My case was the first one to start off in the military commissions, the second one. And the courthouse, it's a commission setting, a commission room, and it's set up to sort of look like an official courtroom. Unfortunately, I mean, it's got flags and a beautiful blue curtain. It looks beautiful. It looks like a set. And because when you look above the blue curtain, which is where the TV cameras stopped, because they would have closed circuit feeds into other places in Guantanamo Bay for the commanding general and some of the other dignitaries to watch what's going on in the military commission. And they would feed it to a media room where the media who couldn't fit into the courtroom would be able to sit and watch what's happening. The camera cut off right at the top of the blue curtain, so if you just were watching on TV, it looked very, very official. Above the blue curtain were wires and vents and all sort of writing, and it was a set. And we started calling it the set. And I remember when I walked out the first time, I'd never had this feeling. I'd never had this feeling before that I was actually going to be litigating in a system that what I was doing was unlawful, that it wasn't a regularly constituted court, that it was a show trial, and it's hard to explain because you're not there. It's a feeling you have, and I'll never forgive it, or excuse me, never forget it. It was clear to me that we would not stand by and let our service members be tried or Americans be tried in this type of system anywhere else in the world, but yet we were doing it down in Guantanamo Bay. Those who are law students, third years, if you've had mock trials, that's what it sort of felt like, where your buddy who's supposed to be the defendant in the case has to study for a advanced constitutional law exam, so he can't be there, so you're not going to have a defendant today. You're just going to pretend that there's somebody there and you're going to argue and you've got an empty chair and it doesn't really matter because there's no effect, which would all be fine except there are actually people whose lives were at stake. And I don't want to sound like a true bleeding heart, but until you're down there actually playing in this process, I don't think you really understand just how offensive it was. 3 Air Force prosecutors, I mentioned it yesterday or today, it's been a long day, 3 Air Force prosecutors quit because and there's a series of emails on the Wall Street Journal, New York Times, and I think in the Washington Post as well, where they recognized that the system was rigged and that there was destruction of evidence, that there were allegations of torture and abuse, that the information disappeared from prosecutors' files, and that they were really the chief prosecutor had said, we're doing these trials. You don't need to worry about the outcome. What you need to worry about is how the academy and the world will view how history will view these trials. And that's terrible, and that's what we were actually dealing with in 2.0. I'm afraid that after Military Commissions 2.0 stopped, and 3.0 is now starting, that it's no less lawless, no more lawful. Unfortunately, it's also been blessed by Congress. So we may actually see, it's going to put the Supreme Court, I think, possibly in a different frame of mind. And it'll be fascinating to see what happens in the next few years when these cases work their way through. The big picture regarding whether fair trials can be had in Guantanamo Bay. And understand the concept of a fair trial, to a criminal defense attorney in Wyoming, generally representing criminals, folks who did it, You know, a fair trial to me is one where I have procedural protections in place to keep the police from overreaching, keep the prosecutor from overreaching, that would give my guy his day in court. And ultimately, at the end of the day, while I didn't want to admit it or not, you know, a fair trial, what the public would want in a fair trial is a just result. They want a reliable result. They want to know that the person that they say you're guilty, in fact, did the crime. You have that generally in federal court and in state court and in military court. You have that reliability. You don't have it a bit in the military commissions process. And that's the key to this, the concept is whether you're going to get a fair trial. It's not that the procedural protections need to be in place just so that there are certain procedural protections, presumptions of innocence, right to remain silent, those cute legal principles that exist. But at the end of the day, in Guantanamo Bay, there's no way, you're not going to be able to know whether there's a fair result, whether there's a just result, whether the guy actually did it. And that's what's unfortunate, and that's what's really kind of scary. And one of the main problems with it is this concept of indefinite detention. Because, and think about this now, when you have a system where you can be held forever and you can't, where the administration has, they can hold people until they determine that they're no longer a threat and until they're ultimately released. But when you have a system where that really could mean never, what possible incentive do the players, and I say the players, the detainees, the accused, the clients, the defendants, have to participate when they know that, as Jim Taylor, God, that was a good chart, that he had yesterday, when you go through this, assume you decide you want to play in this whole commission process, and you go through all the hearings and the lawyers and the evidence, and which we'll all get to, and at the end of the day you're found not guilty, what happens? Now, there'll certainly be political pressure, and there'll be a lot of political pressure to release the guy. Agreed. And that may very well happen, that the day a guy is found not guilty in Guantanamo Bay, the very next day he'll be released, or shortly thereafter. But understand what you're doing, what you're relying on then. You're relying on political pressure, because there's no legal regime in place to make the guy go home. You can be acquitted and go right back to Guantanamo Bay. If you're convicted, you stay in Guantanamo. If the system's disbanded, you stay in Guantanamo. If you're acquitted, you stay in Guantanamo. And when you look at it that way, through the eyes of someone sitting in Guantanamo Bay, what incentive at all do you have to cooperate and put on a trial that you think is rather illegitimate anyway, when at the end of the day, the only people who are benefiting are your captors by being able to say, look, we gave these guys fair trials, and then you go back to Guantanamo Bay, guilty or innocent. So the indefinite detention problem really permeates this entire argument, because it affects the ability to form an attorney-client relationship. Those of us who are lawyers who are used to having clients where we look across the table and the client gets to pick, help me get out of jail, help get me off, get me less time, help me in my divorce, help me do all these things. You don't have that in Guantanamo Bay, because you have this indefinite detention policy where it doesn't really matter. Assuming maybe I can understand and accept you, American military attorney, to be my lawyer, and that you're actually going to have my best interests at heart when you give me advice. Maybe I accept that. But at the end of the day, what does it get me? It gets me right back in Guantanamo Bay. The administration early on recognized that they didn't want lawyers in Guantanamo Bay, because they believed that lawyers would screw up the interrogation process. They may very well be true, but understand now we're back to that conflation principle now. Just because lawyers are going to screw up gathering information doesn't mean that it's going to be perfectly acceptable for 4 years after the fact for you to turn on a spigot and say, now you have lawyers, have at it, establish attorney-client relationships, and have your day in court. Oh, by the way, the lawyer's a military guy who really works for me, not you. And oh, by the way, you can't get rid of him whether you want him or not. You have no choice. You have to have him speak for you. I'm sure it sort of shows what the relationship is, or what the damage is to the relationship down there. The other big picture problem with Guantanamo Bay and the military commissions, along with the indefinite detention, is there is no concept, and I said it was lawless. There's no understanding of what law applies. I would engage the prosecutors on issues and the judge on issues, and they would cite a federal case and then come back the very next few minutes later and say, well, federal law doesn't apply in this case. And they'd cite the military, some old UCMJ court-martial case, or they'd cite Quirin or Yamashita, and then at the same time argue that, but that really that law doesn't apply. The only law that applies is the law that's made up by the Secretary of Defense. And that was bad then, and it was terrible then, and it's going to be as bad now. There is no understanding among the players involved of what the law and procedure is. And when you look at it through the eyes of an individual defendant, the one thing you want, one reason you have an attorney is to provide some information and guidance to this process. How do you advise a client to do anything when you have no idea what the law is? Because it literally would change all the time. I was engaging the presiding officer, then they're called the presiding officers, now they're called the military judge. It's the same guy, but I would engage the presiding officer on how he was going to deal with the evidence that was derived from torture. Because in Military Commissions 2.0, torture was okay. As long as it's reliable, torture is good. And he and I started talking about tortured evidence, and he brings up sticking red-hot needles in people's eyes, and whether or not evidence that's derived from sticking a red-hot needle in somebody's eye would be admissible in his court. I'm a trial lawyer. I couldn't believe he was engaging me on sticking red-hot needles in people's eyes in front of international press, but I thought, if you're going to engage me on sticking red-hot needles in people's eyes, have at it. But it turned out, he says, at the end of the day, would I admit that evidence? I don't know, but I can't say that I wouldn't. Well, the media grabs it. They run around. There's a DOD spokesman down there. She ran off and hid. And then they brought this poor military commission spokesman, a major, a female lawyer like myself, who was speaking, the public affairs person on behalf of the Office of Military Commissions. And the smart media down there, they just killed her, asking her about all this torture needle in people's eyes and all that stuff. And she admits, yes, we could stick needles in people's eyes, and that's okay. Well, that gets, everything goes crazy. And then what happens about 2 weeks later is the Department of Defense promulgates a rule, says you can no longer stick needles in people's eyes and have evidence that's derived that way. Military Commission Instruction, I think, number 10. And that's how the law was developed. I swear to God, the law was developed on the fly in reaction to stuff like that. Suddenly, you can't engage in have evidence that's derived from torture. Can people receive a fair trial when the laws are truly being made up and the rules are truly being made up on the fly? Absolutely not. The main structural problem with the military commissions is the legal issue may be better for the positions of the government. The administration may be a little bit better now that Congress has created the Military Commissions Act. But the structural problem of Guantanamo Bay military commissions, the structural problem is the same. And that is, you have the Military Commissions Act is passed by Congress. That's fine. You finally have Congress speaking out. Wrongly, but what are you going to do? It was an election year. Then they delegate to the executive branch, to the Department of Defense, the authority to promulgate all the rules. Now, those rules are those same crazy rules I was just talking to you about, sticking needles in people's eyes, changing, becoming a military commission instruction number 10. And what the Department of Defense then promulgated was the Manual for Military Commissions, which consisted of the rules for military commissions that are loosely based on the rules for courts-martial, and the military commission rules of evidence, commission rules of evidence, can't remember the acronym, which are loosely based on the military rules of evidence, which are very, very, very firmly based on the federal rules of evidence. But these are all promulgated by the Department of Defense, who is, according to the law, according to the Military Commissions Act, and just truly is the prosecutorial agency in this process. So you have the prosecutorial agency in this process, the same person who supervises every single one of the players, and it's not simply that this, in theory, the Secretary of Defense supervises Private Miller of Alpha Battery, 3rd of the 5th Field Artillery at Fort Sill, Oklahoma, and you have to but you get through 97 layers before you get to the Secretary of Defense from Private Miller. You know, at our level, it's my boss is the Chief Defense Counsel. His boss is the General Counsel for the Department of Defense. And what does the General Counsel for the Department of Defense do? He's the legal advisor to the Secretary of Defense. The convening authority, this person who sort of makes up some of the rules and handles all the logistics for the military commissions, is appointed directly by the Secretary of Defense. The chief prosecutor is supervised directly by the convening authority, who is chosen and supervised directly from the Secretary of Defense. So it's not 97 layers, we're talking 1 to 2. And within that small level or number of players, you have got this system created, and you've got the rules being promulgated. And unfortunately, as bad as the Military Commission Act is, and it's a bad law, the Military Commission rules that have been promulgated are 10 times as bad. It's the rules that have allowed the prosecutors in this case to really do some crazy things. There was an article in the Wall Street Journal that talked about how rule for Military Commission 109 is the rule that they made up involving the professional conduct of its lawyers. They recognized that they need to be able to make the lawyers do certain things, including the defense lawyers, because if we listen to our state licensing authorities, they may say, look, you can't participate in that crazy trial system. It's unethical for you to do so. So they're crafting their own professional responsibility rules to govern the lawyers in this process. You know, that rule doesn't exist anywhere. It just came out of nowhere. Congress didn't mention it. It's not in the Military Commissions Act, but it's in the rules for the military commissions. When you look at how evidence is going to be offered up and produced, the access to evidence, the ability, the use of protective orders, and the discovery process, all these core principles to a trial system, they're not dealt with by Congress. They're dealt with by the Department of Defense, the prosecutors in this process. So that, you know, and I can't emphasize how important the structure of this thing is, so that you understand that when you hear lawyers fighting over concepts and rules in Guantanamo Bay, you're really fighting with your boss about trying to have him do something differently. It's bizarre, and it's violative of, at least in my opinion, it's violative of the rule of law. You have laws that are made up. Everyone understands ex post facto in a very general sense. You know, down there you have laws that Congress has decided to make punishable by a military commission, material support for a terrorist organization, which was not an offense triable by a military commission under Military Commission 1.0 or 2.0. Now it's an offense triable by a military commission, which may be fine and dandy if you want to try it to folks in the future who may provide material support to terrorist organizations, but they're going to try it to folks who've been in prison for 5 years. And I'm not going to get into the very nuanced and difficult legal arguments behind the application of ex post facto to material support to conspiracy and other crimes that either were not or arguably were not triable by a military commission prior to the Military Commissions Act of 2006. But they're going to be an issue, we think. One of the last substantive structural problems to the military commissions, to a trial by military commission,
is this dispositive determination by the CSRT. And if you remember, the Combatant Status Review Tribunal was the organization that was set up loosely based on the Article 5 tribunals, where a panel of military officers would determine, based on a certain amount of evidence, whether someone either was no longer an enemy combatant or still an unlawful enemy combatant. But that determination was dispositive as far as jurisdiction goes for the Military Commissions Act. Now, when the government in the Military Commissions Act, and when Greg mentioned this and Jim mentioned this, evidence that's derived from torture isn't going to be admitted in the Military Commission. Fine and dandy. Except as lawyers, we know that the jurisdiction of the person, the personal jurisdiction in order to be tried by the crime, is something usually that is proved before the tribunal that is actually going to find you guilty or innocent of the crime. Government doesn't prove jurisdiction. Yeehaw, you win, you get to go home. Well, now they don't have to prove jurisdiction because they've already proven it. And they've proven it before a tribunal where evidence that is derived from torture is admitted, where there is no right to an attorney, where the guy 3/4 of the time doesn't show up, where he certainly doesn't see any evidence that the person that's supplied to help him is a government agent. Now, that is evidence that is absolutely would be prohibited before the Military Commission. It's dispositive, though. So you don't even get to really bring that up too much at the Military Commission level. It's brilliant, and again, if it wasn't so scary, it would be somewhat funny if in a mock trial setting. But you're going to have evidence that is bad evidence, not admissible before the Military Commission, which is going to be the basis of the jurisdiction to have the guy tried before the Military Commission in the first place. Lastly, some case-specific issues and some reasons why, based on actually going down and playing in Guantanamo Bay, I can certainly, yes, it's my opinion, but this is a fairly learned one, if I could be learned at anything, that the commissions themselves won't provide for even the semblance of a fair trial, is that there's not going to be any witnesses in Guantanamo Bay. Usually when you have a trial, you have witnesses, but you can't subpoena people to Guantanamo Bay. There's no power, unless Congress would like to pass another statute. There's no statute to allow you to subpoena witnesses to Guantanamo Bay. So you're going to have a trial without witnesses, which is fine and dandy, because the next thing that they've done is they've created this horrible system which will allow, in a worst-case scenario, the laundering of evidence that's derived from cruel, inhumane, degrading treatment or outright torture to be admitted by essentially being laundered into evidence. And in a best-case scenario, doesn't provide the guy a fair trial, really. You can choose which one you'd like to grab a hold of. They created this national security privilege, which was which allows the government to invoke privilege on areas of national security. And unlike the procedures that exist in a normal military court, unlike the procedures that exist in federal district court where you're dealing with classified evidence, this is much broader and much more dangerous, because it essentially gives the judge and the prosecutor the ability to have these ex parte communications and decisions, and make decisions based on the judge can decide what evidence he wants to allow the prosecutor to use without letting anybody else see it, like the defendant or the lawyer. It allows the admissibility of hearsay, unlimited hearsay evidence, and it puts the burden of defending against the hearsay evidence on the opponent of the evidence, on the defendant. So the rule essentially is that evidence, if the judge deems evidence is reliable, then the hearsay comes in, the burden is on the defendant to show the evidence is unreliable. Well, how would a defendant show the evidence is unreliable? What would make evidence unreliable? Well, if it was gained from waterboarding somebody, I'd like to say that that's unreliable. Unfortunately, waterboarding somebody, whether a particular person was waterboarded or not, falls within the classified evidence privilege. So they're going to be able to, so sources and methods of interrogation are privileged. How this is going to work, and this is the beauty of it, is the interrogators are classified, privileged. The mode of interrogation is privileged, and the burden is on the defendant to show that the statement taken by somebody under conditions that we have no idea, is it admissible? You're going to have an evidence custodian or somebody else come up, offer a sworn statement from, we'll presume they're going to let us know who the statement was made by, which says, Mr. Defendant is a terrorist, I saw him do these horrible things. We're not going to know who took that statement. It's not going to be the guy on the stand. It's going to be somebody else. It's Mr. Blackline. We're not going to know who took that statement, and we're not going to have any idea under what conditions the statement was taken. I can't ask the interrogator. I can't ask the declarant, the person who gave the evidence. And then the burden is on me to somehow glean from nothing how the individual, whether that statement is, prove that the statement is unreliable. And if I can't show it's unreliable, it's admitted. My cross-examination would go something like this. Was that statement taken by torture? I don't know. I can't tell you how that statement was taken. The guy who took that statement, has he ever done any horrible things to other people? I can't tell you, because not only could I tell you not what he did to other people, I can't tell you who took the statement. Thank you very much. And then unless I'm able to show it's unreliable, it's admitted. Of course it's going to be admitted, which is great because you can't get witnesses there in the first place, which puts you back to the premise you can't have fair trials in Guantanamo Bay. This hearsay, national security privilege burden on the defense to show unreliability is horrific. And if it truly plays out the way I expect it to play out, I would believe that it's not even going to come close to providing for a fair trial. The access to evidence is, well, there is no access to evidence. It used to be they had lawyers present, the defense attorneys present, and what the government would do is they'd give the defense attorney all the evidence, and the defense attorney couldn't show any of the evidence to the guy, but that really didn't matter because he didn't have a right not to have you there or to have you gone. He had to sort of listen to you anyway, and he could be kicked out of the room. So you were just sort of the lawyer, the military officer, and you just pretended like it was a mock trial, put on the trial advocacy exercise, and that was okay. But at least the lawyer got the evidence, and assuming that there was some sort of relationship between the lawyer and the client, maybe the right thing was being done. Now, they're not going to give the evidence to me or the guy. So you're going to have situations where the evidence, they're actually going to have less evidence that's presented, that's available to the defense, because the court, or excuse me, Congress is making the military commission's prosecutors let the person see the evidence that's going to be admitted against him. That was the big thing in military commissions 1.0 and 2.0, is that there's no requirement to even see the evidence. They'd kick the guy out of the room, they'd offer a bunch of evidence up to a jury, and he would never know what happened. Now, because he gets to see the evidence, they had to figure out a way to make it so that they could still get convictions without letting him see classified evidence. And there may very well be a good reason not to let folks see classified evidence, and that'd be a fine debate to have. So what they decide to do is they would not give much evidence to anybody. So now I'm not going to get much evidence. He's not going to get much evidence. Again, the burden's on us to keep that evidence out under some form or fashion. But at the end of the day, the focus on the evidence and the focus on the fact there aren't going to be any witnesses, the multiple layers of hearsay, which really, when you hear about hearsay, why is hearsay so bad, so unreliable? Well, we've had hearsay for years. My gosh, up until 2004, Crawford 04, up until 2004, there's still a bunch of exceptions to the hearsay rule. It's a little bit tighter now, but we've dealt with hearsay. Hearsay can sometimes be reliable. It's always on the proponent of the evidence to show the reliability, not the guy trying to keep the evidence out. But when you think about hearsay in terms of swapping the burden on the defense and classifying how evidence was derived and who the evidence was taken by, and making that privileged, it really shows, I think it highlights the fact that what's going to go on in Guantanamo Bay in the next few months is going to be really Military Commission System 3.0, which is the same as 1.0 and 2.0. Looks a little bit differently, but it's a show trial nonetheless. And I appreciate Congress stating I think twice in the Military Commission Act that these are regularly constituted courts which have all the guarantees recognized by civilized peoples. I don't know if that means a hill of beans. I don't know if Congress gets to say whether this is or not. I think it's the role of the court to say so, but I guess we'll find out in a few years. But I'm here to tell you that these trials certainly aren't going to lead to reliable results. With so many people in Guantanamo Bay who are factually innocent, and I think even the staunchest supporters of the administration's detention interrogation policies would admit that the number of people in Guantanamo Bay who are factually innocent is much greater than the number of people who are factually innocent sitting in U.S. prisons convicted in Article III or state courts. Because of the number of people that are factually innocent in Guantanamo Bay, there's a very, very real risk, and it's an almost certainty that people are going to be convicted and that the results that are offered in Guantanamo Bay is not reliable. I guess the last thing I had to, think about this when you read the Military Commissions Act. I'm going to throw this out there and then I'll shut up and sit down. But according to the Military Commissions Act, evidence that's derived prior to December 30th of 2005 or 31st of 2005, which was the date of Senator McCain's Detainee Treatment Act, which limited what interrogators could do to individuals. That was the date. Another issue of conflation, detention principles conflated with trial principles. They say that evidence that's derived before that date is admissible if it's reliable. Evidence that's derived after that date is admissible if it's reliable and not gathered, or not evidence that would be gathered from methods which were cruel, inhumane, degrading, or degrading treatment. Whether torture is waterboarding is torture, waterboarding is clearly cruel, inhumane, or degrading treatment. What the Military Commissions Act is in Guantanamo Bay, everything is on its head. If I waterboard somebody on December 30th of 2005, that evidence, older evidence, is admissible. If I waterboard somebody on December 30th, 2006, much newer evidence, law students usually evidence that's closer in time to being on the date it's more reliable, it's fresher. That evidence is not admissible. There's no concept of reliability of evidence. It's all based on immunizing interrogators and providing standards for interrogation that our interrogators could follow. The Detainee Treatment Act, which is fine and dandy. If you want to immunize interrogators, have at it. But don't take that December 30th, 2005 standard or date and somehow apply that into the reliability and admissibility of evidence. Because if you do, you've got the crazy scenario that I just outlined, where old waterboarding evidence is admissible, and new waterboarding evidence is not, and I would hope that people would recognize that that's nuts. Finally, will the commissions be full and fair? I ask you to think about David Hicks, an Australian. He was held in Guantanamo Bay for 5 years. And when he went down to Guantanamo Bay, in his last 2 weeks ago, he had 3 attorneys, 2 civilians and a military guy. The civilian attorneys were quickly kicked off by the judge, as explained by Jim Taylor. What Jim forgot to mention is that Dan Morey had been threatened with prosecution by the chief prosecutor of the military commissions because Dan was very, very aggressive in his representation and was down in Australia telling the Australian people what the military commissions are all about and that their guy is not going to get a fair trial, and it worked. Australia became up in arms middle of 2006 all the way to early 2007. The Australian government, John Howard's government, they're in trouble. And people are turning and wanting a fair trial for David Hicks. So what happens when he goes down to the military commission? Well, now this is the guy who's the worst of the worst, killer, picked up the battlefield. And you know these guys are the worst of the worst because these are the guys who are actually trying. You know, they're not the folks who are held in Guantanamo Bay that can be held forever that aren't going to go before the military commissions. In theory, the war criminals are the ones that are going to go before the military commissions. The bad guys are going before the military commissions. What did David Hicks do? Well, he gets to Guantanamo Bay. There's this weird political pressure that John Howard's been beating up the vice president and the president, saying, if there's another delay in this process, I have an election in November, I want my guy back. It's entirely political. And so what happens, he gets down there, the judge kicks off his 2 civilian attorneys, the military person, or the 1 civilian lawyer in my office because she was funded and paid for by DOD, and the other civilian attorney because he wouldn't agree to sign by the professional responsibility rules that I talked about, which actually haven't been promulgated yet. He wouldn't agree to abide by the rules that don't exist. He was gone too. Dan Morey gets threatened with prosecution by the chief prosecutor down there because he was working very hard in Guantanamo Bay. So now that David Hicks is left with Dan Morey, his lawyer, and he pleads to a deal, a 9-month deal, and a 9-month deal, 60 days transfer to Australia to material support of a terrorist organization, and he gets out he'll be out by the first of the year. So how bad is a system of justice where, had he gone to trial and fought the charges and won, he'd still be in Guantanamo Bay. But he took a deal to a 9-month crime with his lawyers being fired, the other military guy being threatened with prosecution. He pleaded an arraignment. I mean, you can't plead at an arraignment. I tried in federal court. They're very tight on the schedules. He pled guilty at the arraignment before any discovery was handed over to a charge, the military commission, the material support charge, which is arguably is going to be the ex post facto issue. Can you try somebody before a military commission on a material support charge who was picked up in 1999 or 2001? Waived his right to appeal, which is important. He has to waive his right to appeal because they'd look at that material support charge that he pled to, and they'd look at the fact that his lawyers were kicked off the case. And he had to state that he wasn't mistreated by the Americans. He wasn't treated illegally, which he had always stated that he was, which there was evidence that he was mistreated. Now, they worked around this because they worked over the word illegal, and because the administration's position is that prior to the Detainee Treatment Act, it was okay to treat people cruelly, inhumanely, and do degrading stuff to them. Ta-da! It's legal to do that, and David Hicks, while he may have been waterboarded, if it's not torture, it wasn't illegal because of the Military Commissions Act, the Detainee Treatment Act, finally codifying the standard in 2005. So he has to say he wasn't mistreated. He's gagged for a year, which is just long enough for the Australian Prime Minister to be elected in November. And he gets to go home to Guantanamo Bay in 60 days, while all the other detainees are sitting down there, uncharged, without any rights whatsoever. How many of those folks do you think would plead to crimes they didn't commit if pleading to the crime is the only way that you get out of prison? And that's what the focus of this thing really needs to be on. The only way he was able to get out of prison was to plead to the crime. Everything is on its head. If you're worse, better things happen. If you're perceived to be better, worse things happen. The commissions are just... The final remark, I guess I'll go ahead and paraphrase what my boss, the Secretary of Defense, said about 3 weeks ago during the Hicks trials. He said these trials aren't going to be viewed as being legitimate. Well, they're his trials, unfortunately, and if we're participating in a system that we recognize are not going to be viewed legitimate by anyone, you got to question why we're participating or in the first place. I'll quit now. I'm sorry I went longer than I expected, and I'll answer any questions that folks have.
I guess I need a mic. On the Hicks, my question goes to the Hicks trial. What are the standards for filing judicial misconduct and judicial ethics code breaches against this bozo?
Who's the bozo?
The judge. Because it occurs to me that judicial misconduct has probably occurred under even the military code of justice, which I'm not an expert in. And that's one way that you deal with judges who behave in a manner that does, in my view, a disservice to the title of judge. And it only takes one of those even if it takes a couple of years to review the charges, to get all these other guys in line to start thinking about how they're conducting their court. So what are the standards for judicial misconduct against a particular individual in this position?
There's two different applicable standards, and this is some of the stuff I've been working with Jim on. To the extent that the Department of Defense and the military judge advocates and other folks who promulgate their own separate rules of professional conduct, which all the branches have and the Department of Defense is doing, there will be within that structure a way to complain about the activities of a military judge or a military prosecutor. We have grievance processes just like you'd have in a normal state. But all these people are licensed in a state. And I've always believed that from the moment I got on board on this stuff, I talked to Nancy Hollander while I was still a federal defender in Wyoming and asked her some questions. I was worked up on compelled representation, which was the thing that I focused on for the first year. That legal ethics would be probably the only hammer that folks would have, because that's really the only area that the executive branch is probably going to have to show great deference to the state. So what is the standard? There are mechanisms to complain about a military judge or other military attorney's actions within the departments. There's also a bar complaint that anyone could make in the licensing jurisdiction of the individual attorney. And I mean, you ask a good question, David, because I think at the end of the day, that really may be where the money is made on this stuff. And state bars have got to recognize. I dealt with the State Bar of Iowa seeking an ethics opinion, and it was a bad opinion. And I'm biased, so I can say it's a bad opinion, but it was a bad opinion. State bars have given so much deference to the military and to the Department of Defense in doing whatever they want to do with their lawyers. And generally, you don't have these issues because we try to do a decent job. Generally, we abide by the state rules and the military rules. It's when you push the envelope like this, when you're compelling lawyers on people, where they are compelling representation, forcing lawyers, where you're being threatened with prosecution, conflicts of interest, structures of our offices. You have these issues that are very, very real that state bars are going to have to take a look at, and that may very well be at least part of the undoing of this process. Sir?
Major, my question has to do with the concept of justice. Thank you. The new Secretary of Defense, who's your boss, came from the university system, and he said this last month, as I think you alluded to, that Guantanamo ought to be closed because it's a blot on American justice. He obviously has a concept of justice then that is independent of what's been going on the last 4 or 5 years. Would you say a couple of sentences about that concept of justice? And I'd like to invite Greg, if you would say a couple of sentences about that. I thank you.
Sure. I want to say first that I truly try to. It's being a military attorney and a military officer in this process has been an extraordinary challenge. It's interesting stuff, and it's fun to come up here and talk to people and educate folks, and the stuff is interesting and fascinating. It's difficult because you almost can't do your job effectively unless you engage in some of the questioning of policies, which we just don't do as military officers, or we really shouldn't do as military officers. But military lawyers, as defense attorneys, we have a slightly different role in this process. And I really appreciate the Department of Defense recognizing it's very, very difficult for us to divest ourselves of the advocacy role and completely not look at some of the policy considerations. With all that being said, I don't want to discuss straight up, the policy of whether my boss, the Secretary of Defense, understands a rule of law or some concept of justice. These decisions are made echelons above me. If I were asked my opinions whether Guantanamo Bay should be closed or not, I would echo the Secretary of Defense's positions that he believes that Guantanamo Bay would be closed. I would also believe that most folks in the administration don't have much desire to have Guantanamo Bay open any longer than they absolutely have to. It doesn't explain why they're continually building prisons, But they still, because we're on number 6 now, but that, with all that being said, I don't impute any bad faith on any member of our government. I think that I am, just personally, I'm much more, believe it or not, I'm much calmer now than I was when I took this job, because I recognize now that the decisions that were made after 9/11 were much more difficult and complex than I ever imagined when I originally took this job, when I thought you just can't be picking people up and holding them forever. So I don't want to get into motives, but I would recognize, I think that certainly the new Secretary of Defense has a more accommodating policy on Guantanamo Bay, and hopefully, and I think the whole executive branch is starting to move that way. But again, there's no ill motives. I disagree with the way things have happened, and hopefully in the future we can sort of get on the right track.
Greg, do you want to comment on that or any other parts of Tom's presentation?
Yeah, on the specific question about closing Guantanamo, I think I've addressed that. I don't think it would be just any more than it would be legally compelled in order to release folks like Khalid Sheikh Mohammed and Abu Zubaydah and Ramzi bin al-Shibh. There has to be somewhere where al-Qaeda leaders like that are detained. I don't think it makes sense either from a legal perspective or from a security perspective to bring people like that into the continental United States. I also don't think it makes sense to move people like that somewhere like Afghanistan, which I think was suggested earlier. One of the principles of detaining enemy combatants is that you are supposed to keep them in an area that is secure and removed from hostilities, both to ensure that you can continue to detain them and to protect the safety of the detainees themselves. So in terms of finding a location that is removed from the United States proper and as secure as possible to carry out the critical detention function, Guantanamo seems to me the right answer. With respect to some of Major Fleener's comments, I think we agree completely that the detention principles and the military commission prosecution for war crimes principles should be independent. I tried to unpack them as best I could in my talk. We've tried to keep clear in cases where we're talking about detention of enemy fighters because they're enemy fighters, and where we're talking about criminal prosecution because we think particular fighters have committed war crimes. I don't think it's right to say that because the government has these independent authorities, the detention authority somehow fundamentally infects the military commission, the prosecution function. These authorities have always existed in wartime. The limiting principle on the detention authority is you can only detain combatants for the duration of the relevant conflict. If we were to get lucky and get bin Laden and al-Qaeda were to fall apart, with that would end the lawful basis for detaining al-Qaeda fighters during an armed conflict with al-Qaeda. Independent of that is the possibility of any detainee to secure release through an administrative review board, which is the annual tribunal that reviews the need for continuing detention. That is by no means an illusory one, and a few dozen of the detainees have in fact been released through that process. So a detainee facing that kind of exposure for detention as an enemy combatant is in a very different position from a detainee convicted for a war crime who could for a capital offense be put to death, for a life offense be held for the rest of his life, wholly apart from whether the underlying conflict continues. So I think the authorities are independent, the justifications are independent, and the limiting principles are independent. And all of what I've just said, it seems to me, is itself independent of sort of where you come out on the question of whether this conflict is different from past ones, because you have always had these two authorities sort of exist side by side. A lot of Major Fleener's arguments were structural ones, that it is impossible to have a fair criminal prosecution function in circumstances where the adjudicator and the defense lawyer are in some sense in a command relationship with the President and the Secretary of Defense, who are also in some sense the prosecuting authority. Let's be clear about the implications of that argument. That is an argument that there can never be any military commissions. It is also an argument that there can never be any courts-martial, because it is any fair courts-martial, because it is equally true with respect to courts-martial that the judges and the defense lawyers stand in a hierarchical relationship with the Secretary and the President. If you have any doubt about whether American service members who are called upon to be either judges or defense counsel in this process can effectively discharge their responsibilities in serving that role, I can think of no better argument to dispel that doubt than to simply refer you to the eloquent presentation that Major Fleener has just
the
delivered.
downside of coming.
Ask yourself whether it is realistic to think that someone who just gave the kind of advocacy that he just gave is, because of his structural relationship in the military, incapable of providing a vigorous and forceful defense. I think that question answers itself, and I think one can draw the same conclusions with respect to other defense counsel who have been quite effective in representing their clients. I mean, the reason why there have been almost no prosecutions is because of the effectiveness of their advocacy. And I think one can draw the same conclusion with respect to the American service members who are called upon to be judges and who are ordered to perform a neutral role in adjudicating the guilt or innocence in individual cases. With respect to substantive arguments about the procedures, I just respectfully disagree that what's been called 3.0 is just sort of made up on the fly, and I would just invite you to read the Military Commissions Act, which looks like an intelligible trial code which codifies the governing rules, creates a presumption of innocence, requires the government to prove its case beyond a reasonable doubt, permits a detainee to testify or remain silent, permits a detainee to put on evidence, to cross-examine witnesses, on and on and on. The extent of protections is spelled out in far greater detail than has traditionally been done in the commission process. The rights are more protective than has traditionally been done in the commission process, and are more protective than done in the analogous context of international war crimes prosecutions by international tribunals. If you look at the protections provided under this statute versus those typically provided to this day when international tribunals prosecute for war crimes, those provided by Congress will stack up quite well. With respect to classified evidence, the statute sets up something approximating the Classified Information Procedures Act, which is the way the system deals with this problem in Article 3 criminal trials. It is frankly not ideal from the government's perspective of protecting classified information, but it seems to me a not unreasonable compromise of the competing interests at play. With respect to combatant status review tribunals as the jurisdictional predicate for military commission prosecutions, again, those procedures are more protective than the Supreme Court said would be good enough in the context of American citizens in this country being detained. And in the prosecution context, they are only used to make a threshold determination whether or not the trial can go forward. Nothing that happened in a CSERT affects the need for the government to prove its criminal case beyond a reasonable doubt or the conduct of the criminal trial as it goes forward. Finally, with respect to Hicks, it is a practical reality that in the prosecution of wars and the conduct of foreign policy that there are a lot of cross-cutting pressures that the president and the military operate under, and some of them are diplomatic ones, and it is neither surprising nor troubling, I think, that the executive takes diplomatic considerations and constraints into account just as it takes other competing considerations into account in particular cases.
I just have one short comment to make about combatant status review tribunals. They're not a process at all, really. They're a Mobius strip. You get on them, you can't get off. They're not comparable to an Article 5 tribunal. Article 5 tribunals, the Geneva Conventions provide that if there is an Article 5 tribunal, if there's a question about someone's status, they're entitled to prisoner of war protections up until their status is actually determined. That doesn't happen in combatant status review tribunals. You start on that Mobius strip, you're already an enemy combatant, and it's just up to the discretion of the government if you ever step back off it. The other thing about Article 5 tribunals is they're designed to be a field tribunal. They take place in the field after capture. If there's a question about your status, evidence is available. If people want to question their status, you can go get the people that know the facts. They're not held 5 years later halfway around the world where you don't have access to the evidence, you don't have access to the witnesses.
What's a Mobius strip?
A Mobius strip? Yeah. It's a strip that only has one side. You can only get, once you're on it, you can never get off. You take a piece of paper, you put a half twist, you glue it back together, it's only got one side.
I don't think that's a fair characterization of CSRTs because they are charged, each CSRT is charged with making a determination whether or not the detainee is an enemy combatant. If they come back with a no, that determination conclusively eliminates as a justification for detention the proposition that the detainee is an enemy combatant. Now, you mentioned last night there is an independent problem about repatriating people. The Uyghur case has been discussed. The Uyghurs were people found not to be enemy combatants, some of them, in the course of combatant status review tribunals. It's true, they were not immediately released. Why is that the case? It is not the case that we think we can just ignore that determination and go on detaining them as enemy combatants. The reason why it took some time to release them is precisely because we have obligations under the Convention Against Torture. We take those obligations very seriously, and we couldn't repatriate the Uyghurs without exposing them to a threat of torture, and we had to find another country willing to take them. That took some time. The fact that it took time to find a country willing to take the Uyghurs in no way undermines the dispositive legal effect of the Combatant Status Review Tribunal that concluded that they were not appropriately detained as enemy combatants. With respect to the question about POW status, the CSRTs apply with respect to Al-Qaeda and Taliban combatants only, and there's just no, I don't think there's any reasonable basis for doubting that the Taliban and Al-Qaeda, most clearly Al-Qaeda, don't satisfy the requirements for POW status. They don't wear uniforms. They don't carry arms openly. They don't have a military-like command structure, and they don't follow the laws of war. So there may be very serious open questions in any particular case whether a detainee is a combatant on the one hand or an innocent person swept up in the war on the other hand. I don't think there are serious open questions about whether that person, if a combatant is a combatant who satisfies the requirements for POW protection under the Geneva Conventions.
Well, and that's the whole point of the Article 5 tribunal is you've got somebody who's authorized to make that decision and decide they are a prisoner of war, they're not a prisoner of war. It's another feature of what the administration has done by coming to the conclusion before the process starts, and there's no way, again, off that strip.
Do you really think there's a litigable issue about whether particular members of Al-Qaeda wear military uniforms and
No, but
carry arms
that's what
openly
the
and follow
purpose-
the laws of war?
That's what the purpose of an Article 5 tribunal is to
It's-
make that determination whether this particular individual is not a member of Al-Qaeda or not, but is or is not a lawful or unlawful combatant.
It's to adjudicate status, which in this context means either combatant or innocent.
Hey, I want to read something real quick about CSRTs. Out of the 102 CSRT reports that were released and processed through Seton Hall Law School, no witnesses or documentary evidence was presented in 96% of the cases by the defense. Requests for the witnesses were denied 76% of the time. 3 of the 102 cases that were looked at, the guy was found no longer to be an enemy combatant. In all 3 of those, they made him do it again and gave him a new C-cert. And in 2 of the 3, the new C-cert came back and said, okay, you really are an enemy combatant. And the third, the one guy who had beat the C-cert now twice, they did another one. And this time they came back and it was a 2-1 split, and they found him still to be, they actually did it over and found him to be an enemy combatant. I want to read something. This was Mustafa Ait Adir, some transcripts from the CSRT. These are all unclassified now. The CSRT, you have associated with a known Al-Qaeda operative. Mustafa, give me his name. CSRT, I do not know. Mustafa, well, how can I respond to this? CSRT, did you know anyone that was a member of Al-Qaeda? Mustafa, no, this is something the interrogators told me a long while ago. I asked the interrogators to tell me who this person was. Then maybe I could tell you if I might have known this person. But not if he was a terrorist. Maybe I knew this person as a friend. Maybe it was a person that worked with me. Maybe it was a person on my team. He was an aid worker. But I do not know if this person is Bosnian, Indian, or whatever. If you tell me his name, then I can respond and defend myself against this accusation. I'm now prepared to tell you. If you have anything or any evidence, even if it's just very little, then I'm ready to be punished. I can just tell you that I did not plan anything. I was hoping you had evidence that you could give me. Then he finally says, because these are accusations that I can't even answer, I'm not able to answer them. You tell me I'm from Al-Qaeda, but I tell you I am not Al-Qaeda. I don't have any proof to give you except to ask you to catch bin Laden and ask him if I am part of Al-Qaeda. I don't have any proof. I don't have proof regarding this. What should be done is you should give me evidence regarding these accusations, because I'm not able to give you any evidence. I can just tell you no, and that's it. This was the guy who the third time around was found to be an enemy combatant after beating 2 CSERTs. For what it's worth, one of my main problems with the detention policy is I think that the CSERT program is the really, if you're going to be able to detain somebody in this new war without charges, where you don't really know who the enemy is, you don't really know who the battlefield is, where the battlefield is, you don't really know when it started or when it stopped, then the CSRT process needs to be much more like, and especially much more like a legal process, and especially because the CSERT now is held 5 years after the fact. We're not worried about the problems like an Article 5 tribunal would have, where we need to get somebody off the battlefield. Time is of the essence. There's exigency. There's no exigency in CSRTs. If I were king, what I would do with the CSRT process would be almost turn the CSRT process into the military commission process. Because again, I think that the big issue is, are we holding the right guys? If we're holding the right guys, then that's another question. What can we do with them? How do we get the information? Is it safe to let them go? That's stuff that you're going to find much more agreement on. The problem is we're not holding a lot of the right guys. So I guess I would opt for a CSERT process that has a little bit more teeth, where you don't have somebody who, again, beats it twice, gets stuck a third time. Anyway, that's my take on the CSERT process. I didn't want to interject myself in y'all's conversation, but.
Are there other questions? Dan?
Yeah, this is to Tom and Greg. It seems like you're on different planets. The process Tom just described, and then your take on that same process, and it seems, and going back to what Tom said yesterday, it seems like we get buried in sort of the legal questions, and when you stand back and look at it, it's just ludicrous. That exchange that he just read is
Terrible.
Is worse than what Kafka could ever come up with in his wildest dreams. I mean, have you folks read any Kafka? I mean, this is the future that Kafka predicted rather than Orwell. I mean, this is it, where these rules that Tom was talking about, where you have to prove the hearsay is unreliable. Well, they won't tell you who said it. I mean, it's just ludicrous. It's Kafka couldn't have come up with anything worse. So I don't know if that's a question, but the question part of that was, have you read any?
I've read a little bit. Unfortunately, I live it. I'd much rather read it. All joking aside, I appreciate Greg's position on this, and it's coming here and talking on speaking about this stuff is it's extraordinarily important to hear both sides. The CSERT process, respectfully, is broken, and again, there's a couple easy ways to tell who's telling the truth. Let's let people watch them. Now, you can't do that because, one, the guise of a national security issue, but two, people would see this crap. And if folks saw this, I read this thing to you, but you have to dig around to find these things. The benefit of secrecy, secrecy is a two-edged, double-edged sword. I mean, you get the benefit at least of keeping things secret. Unfortunately, you're also faced with, or you should be faced with, real hard questions regarding what's taking place behind the closed doors. And what, with all due respect, I think what the administration has been wanting to do and has been doing for the last several years has been invoking the secrecy and then just saying, trust me, we wouldn't do these things. And if you get this stuff, you get the guy saying, show me, how am I supposed to tell you I'm not from Al-Qaeda? What evidence would I give the guy that I'm not from Al-Qaeda? I mean, I don't know what I'd show him if I was sitting in Guantanamo Bay trying to come up with evidence that I wasn't from Al-Qaeda. But yeah, again, it's the CSERT process is the problem. I think you can take a step back, though, and ask yourselves, that maybe this is what you get eventually when everything's a secret. And when you step back, we're back into the 50s in the McCarthyism era. When everything's a secret, you either rely on goodwill, which unfortunately there's not a lot left, or you expose it. And the best way to answer these questions over who is right regarding the CSERT process does the CSERT process actually classify individuals who are enemy combatants, or does it just sort of classify everybody as an enemy combatant and is a horrible, disgusting mess? The answer is to open the doors, let people actually see it.
Yeah, I think your question goes to the classified evidence issue in the CSERTs. In terms of how status determinations have always been done, if you look at the 190-8/Article 5 provisions, which again are the model for this based on the Supreme Court's suggestion, those provisions expressly contemplate that the possibility of portions of a hearing being closed to a detainee. Let's be clear what we're talking about here. We're talking about informants on Al-Qaeda, and the proposition that your question points towards is that in order to hold an Al-Qaeda fighter, we have to tell that fighter who are the whatever intelligence assets we have ratting on Al-Qaeda. The Supreme Court said in a different context that intelligence sources will close up like a clam if there is even the possibility that their identity will be revealed. In the context of a terrorist organization with the reach and capacity of Al-Qaeda, I think releasing the name of a source is akin to imposing on that person a death sentence. I don't think that's such a great idea, and I don't think that is how status determinations have ever been done. With respect to the Id-Itter case in particular, it's become kind of a cause célèbre because Judge Green, in one of the detention cases, quoted the passage that Major Fleener mentioned. I just tell you that if you look at the entire transcript, the detainee is entitled to have access to all of the non-classified information available. Mr. Id-Itter had access to allegations that were bound up in these issues that we've been discussing. He did, in fact, respond, spoke at length about his associations with relevant people, gave his side of the case, and I'm sorry I'm being a little bit vague here because I have seen the classified evidence, and I need to be careful about not saying anything that I shouldn't and can't. I will just tell you that Mr. Id-Itter, in fact, had an ability to defend himself in the context of his overall proceeding that is significantly greater than that suggested by the one snippet that's been read.
Well, the reason why I asked if you've read Kafka is because what Kafka does is, as you read it, it puts you in the position of facing a bureaucratic structure that is unnavigable, a Mobius strip, where you cannot cannot navigate it. Can you imagine being in a situation where you're incapable of defending yourself by the rules and that the rules just circulate? Can you put yourself in the shoes of somebody who might possibly be wrongly accused and sitting down in Guantanamo year after year? Can you imagine that?
Imagine the competing hypothetical. Suppose that we captured Khalid Sheikh Mohammed not because we had an aggressive interrogation program well, let me finish and I'll come to it. Not because we had an interrogation program that got us the relevant information, but because we had an intelligence asset on the inside of Al-Qaeda who told us that he was the mastermind of September 11 and the brain trust of Al-Qaeda. Can you imagine the government and the Defense Department having to live under a rule that we could not detain Khalid Sheikh Mohammed without telling him who is the informant that gave him up to us? That is simply not tenable.
We have a question over here.
Yes, I couldn't help but think that I was a staff sergeant in the Second World War in the Signal Corps, and I feel very much like like saluting my superior officer today after your presentation, Major Klinger. I found it very inspiring, and I couldn't help but wonder whether all this trouble could have been avoided. A good deal of the trouble could have been avoided. Perhaps 9/11 was more difficult to avoid, but would the situation have been any easier to control, including all the legal procedures that have been going on, if we had not invaded Iraq? And that has added another dimension to this whole so-called war on terror, which of course the administration said was part and parcel of Al-Qaeda, and has proved to be so terribly wrong. Do you think it would have been a little easier? Although I realize that there are good people involved and evil people involved in any situation, and that's another problem that we have to solve. But I really appreciate it, and I hope you, in your introductory statements, when you described your situation in the hierarchy, that you do get support, and I hope that will continue in the future. And I really give you all my kudos for taking your strong stand in this very direct and forthright manner.
Well, thank you. I appreciate that very much. And I guess I'm going to comment on a couple things. First, regarding the strong support. I mean, the attorneys in my office get kicked out of the military and get passed over for promotions. I mean, that's just the truth. So, and I'm backing up on something that Greg said a little while ago, that I'm the example, and others are the examples of why these people are getting fair trials and why this system works. I mean, we're aware of that. And that's my biggest concern, is being a fig leaf in this process and being able to have them point their finger to me and say, look at him, he's good. That's why these guys are getting a fair trial. When I know they're not getting a fair trial. Charlie Swift, who won his case before the Supreme Court, military defense attorney in Hamdan, passed over for promotion, forced to leave at 20 years. He was able to retire, and he's going to be able to come back and continue on the Hamdan case as a mobilized, retiree, recalled guy. But he was passed over for promotion after winning Hamdan. Dan Morey, the attorney who did extraordinarily well in David Hicks's case, navigating those unbelievable waters, passed over for promotion twice. He's going to retire as a major. So do we get the protection from on top? Probably not. You know, I'm an Army reservist. What are they going to do to me? I'm going to go back to Wyoming and do my thing. And I think that's one reason why they're starting to bring reservists into this process, because you don't want to put career military men in a position where they have to choose between representing their client to the best of their ability and working for their military career. It's much easier to grab a broken Army reservist like myself, and we do what we can. As far as the question on Iraq, again, I try to avoid gigantic policy considerations, especially those that are outside of my particular area of interest. With that being said, I think that it's tough to argue that Iraq hasn't affected the war on terror and policies and court decisions and other things that have taken place since we have invaded Iraq and as far as based on how the war in Iraq is going. Judges are, they're not immune from pressures. Politicians aren't immune from political pressure. And Congress certainly isn't immune from political pressure. And I think that it would be naive to say that you take the war in Iraq and completely divorce it from the war on terror and what's happening in Guantanamo Bay. I think probably the correct analysis is that at a minimum, the war in Iraq and how we are perceived in Iraq has certainly affected the tone and the tenor of policies and laws and judicial decisions that have come out since the war in Iraq. And you could probably go farther from there, but certainly I think that at least the atmosphere is different because of Iraq.
We're getting kind of down to the end. Dan's going to shoot me if we go too much over. If there's anybody that's just dying to ask one last question, let's get that out, and then I'll give all the speakers a minute to wrap up. I'll let you go first, and I'll let David go last. Yes.
I want to go back to this idea of the war footing for this whole thing. It seems like, and I really appreciated, Greg, your being here and presenting the case so well. But it does seem to me that the whole rationale for this, everything we've been talking about here really is that we're in a war. And but it's only a war up until it's a war in terms of kind of removing people from constitutional protections up to the point of the Geneva Convention, and then it's not a war anymore. So what it's done in effect is create a huge kind of undefined class of people, enemy combatants, quote, that effectively fall through the cracks through any kind of really effective rule of law. And to me, that seems like a major problem in its own right. So in other words, the rationale on which this whole structure has been built leads to this incredible problem of this huge class of people that essentially, that based on what Debbie said and the other speakers have said, that however you parse it, there's just huge constitutional problems. And the image of the United States in the world has suffered incredibly from this. So that's my take on it.
Yeah, I just, I've said these points before. I have to respectfully disagree on the notion that we're picking and choosing provisions of Geneva and making up terms. Enemy combatant is a term it's used in the Kieran case. It's not something we made up. It encompasses both people who are like regular members of the German army who were entitled to POW protections, and people like the Nazi saboteurs who are subject to detention because they're fighting for the other side, but who are not subject to POW protections because they're out of uniform and not fighting by the rules. And with respect to the point about coverage gaps, now that the Supreme Court has construed Common Article 3 to apply to this conflict, I'll be perfectly clear with you, we thought that was wrong, but we are where we are, it does apply, and I think that should assuage your concern that there are categories, the unlawful combatant category, where people would have no treaty protection. That's simply not the case anymore post-Hamdan.
Well, thank you all. We're going to just move into closing remarks. I will give Greg the opening shot. You've got about a minute, so give us your best shot in 60 seconds.
I think I've said everything, everything that I can. Gosh, if I had to sum up, I think in some ways the administration has been the victim of its own success. And the reason I say that is if you asked people on September 12, 2001, what is the likelihood that we can go 5 or 6 years without a single major further terrorist incident on American soil, the prevailing view would have been that that is not likely. I think we have made it this far, not by accident. The heroic efforts of the military to capture and dismantle al-Qaeda, to get some of the leadership, the people like KSM who were detained, who have given us critical information through an interrogation program, is a major part of why we've had that success. I understand that there is a greater degree of skepticism as of now, 2007, than, let's say, October 2001 about the urgency of the situation. But I think I don't think that our good fortune over the last 5 years can be entirely divorced from the aggressive stance that I've tried to defend here as both important for the national security of the country and consistent with governing legal principles under the federal constitution and federal treaties and traditional law of war understandings.
Thank you. Debbie?
Well, just in short, I'm the person invited to say that the war on terror has a lot of collateral targets. And in some instances, there are serious human rights abuses occurring on allegations of terrorist activity or membership or assistance to a terrorist organization. And the evidence in support of those allegations is either non-existent or sham. And that's the big problem, or a big problem. I mean, there's other issues associated with when you do have the real bad guys, what are their rights? I think Greg asked an excellent question last night. What's the relevant baseline of rights that we're measuring against? And I think that would be an excellent debate to have, but at least with the people that I work with, ones that are trying to get legal status or trying to stay in the country, and these allegations of terrorist activity have been raised. I have yet, granted I do removal defense in Montana, and there's a lot more cases that occur outside of here, but in none of mine where that a person of interest has been identified, in none of mine has the government been ultimately able to come up with any kind of evidence in support of its activities that have kept people in detention and isolation without contact from loved ones or privileged communication with counsel for months. So there are serious human rights abuses occurring in this war, and it's important to talk about them, in my view.
Thank you, Debbie. Bruce?
I agree with the statement that the use of the war paradigm, as I said, was unprecedented. It was wrong. From the beginning, the administration has said that we need new laws of war, even convened in the ABA, a panel to try to do that. From the beginning, from our commander-in-chief calling the people at Guantanamo killers, it has undermined the whole process. There has been very little rule of law. In terms of success, I don't think we've been very successful. We're much less safer around the world, both because the United States is now hated almost everywhere. The Middle East, whether you talk about the strengthening of Hezbollah, strengthening of Iran, is nowhere near as safe as it was. Now, instead of one group, Al-Qaeda, we're fighting thousands of groups because it has metastasized. The people around the world that are thinking like Al-Qaeda have now multiplied. In addition, even our strongest allies are not safer anymore. England, France, they were worried that this would happen, and they were right. I think if we continue to go along this road, we're going to be much less safer. We are wasting our wealth on a misdirected cause. I think unless the people of our country get engaged, and unless there's accountability, including for the lawyers that have been part of constructing these violations of war, because there's very ample precedent now that these are war crimes and there must be accountability, that this is going to happen again. So, thank you.
Major Fleener?
I hear all the time that Al-Qaeda doesn't give people trials. They cut off their heads. That we may treat people poorly or have interrogation techniques and detention policies that are bad, but the folks who are alive. What would happen if one of ours was captured by Al-Qaeda? I'm tired of being compared to Al-Qaeda. I don't want our country's human rights record should not be somewhere better than China and the Saudis, but not as good as all of the other allies that we have throughout Western Europe and the rest of the free world. We do things differently because we're Americans and because we've always stood by the rule of law. I find it troublesome when we are in a position where we have to defend whether or not what we're doing to somebody violates the Geneva Conventions. And I would hope, again, that the comparison in the future is not us to Al-Qaeda, but it's back to no comparison with America. America sets the standard. And I think we have some work to do before we can be in that position.
Thank you. I've just got 3 brief remarks, and then I'll turn it over to David. In 2005, a draft document was released by the Pentagon called the Joint Doctrine for Detainee Operations, and there's a fairly remarkable sentence in there that I think bolsters the point that enemy combatants as a legal concept is a post-9/11 construct. This is the sentence from the document. The document was later withdrawn. It never became an official document of the Pentagon. Following the events of September 11, 2001, a new category of detainee, enemy combatant, was created for personnel who are not granted or entitled to the privileges of the Geneva Convention. That pretty much says it for me that it is a post-9/11 construct. The second point I wanted to make is I think one of the things that's really missing in society today is the kind of debate that we've had the last 2 days. I think we've had a good, reasoned, civil debate, and I think we've got some information out there that maybe hadn't been out in the local community, and I think this was a good step for the community. The last thing, I just want to echo Senator McCain's remarks in the Senate when the Detainee Treatment Act was passed, because he took a lot of heat for his policy as a former POW, he felt strongly about the need to restrict the use of evidence obtained through torture. And Senator McCain's remark was, and again, it was the same kind of comparison was made that what kinds of things Al-Qaeda would do, and Al-Qaeda would not respect the rights of U.S. citizens. And Senator McCain's remark is, this isn't about Al-Qaeda, this is about who we are. Our response to these issues are not about how bad our enemies are, they're about who we are as a nation. So that's all I had to add. Thank you. David?
Tom took the spirit of what I was going to use as my closing remarks and articulated that better than I could. I've got a couple of points. My biggest disappointment in what I've seen the government do to date in the war on terror is take the position that I think I'm accurately about to describe, that we need to figure out the absolute minimum of rights any of these detainees might be entitled to, and stop there. That to me is never what our system of law and justice in this country were ever intended to be about. Every time we have strayed from the higher ground that Tom refers to, we pay a hell of a price. And things tend to get worse in terms of loss of life and going backward than they get better until we somehow manage to self-correct, because we keep coming back to rule of law principles aimed as what I said last night. Principles that protect the individual from government power overreach. That's why we have a Bill of Rights in our Constitution. That's why every part of the world except Asia has adopted a Convention on Human Rights modeled after our Bill of Rights. And if you've not read the various international human rights conventions, I suggest you do so, and you'll be shocked to see the nearly 100% overlap, except for our Second Amendment involving guns, that exist in all of the human rights conventions that collectively most of the countries of the world have signed, if you count the Universal Declaration of Human Rights. They all come back to us. So I think we should be the leader in determining not the minimum amount of rights that somebody has, regardless of whether they've been involved in alleged or even actual acts of terrorism, but something that's objectively a little bit higher. To reinforce that point, and this will be my next to the last comment, we have always been willing, some people more willing than others in this country, to let guilty people go free when their guilt can't be proved beyond a reasonable doubt. I don't see why on earth that principle can't and shouldn't apply to everybody in Guantanamo. Where's the proof of illegality beyond a reasonable doubt? Because that's the international standard, and let me suggest that's ours. If we don't have it, let them out. If our intelligence were any good, and we certainly pay enough money for that, we'd put the ones we really think are terrorist threats to our security under surveillance. Of course, finding someone who can communicate in Arabic or some other language fluently enough to understand what they might be talking about might be a little difficult. We haven't been able to do that since 2001, despite committing all of our so-called resources that we have at our disposal to a war on terrorism. We don't even have 1,000 fluent Arabic speakers in the CIA. And that's just one of many agencies that have been formed or named to fight the war on terrorism. Let me have a fraction of the money in Iraq that we're spending, and I can solve that problem myself. But the last thing I want to mention is is a point I made last night. I want to commend the lawyers that are working diligently in this field on behalf of the individuals who have found themselves caught up in this war on terrorism. And I'm going to include the lawyers for the government. Greg's got a hard job, because when all is said and done, I guess I have a slightly different opinion than my good friend and colleague Bruce Zagaris has. I think it is a war, and I'm more than willing to adopt a wartime paradigm here in terms of how we're trying to confront terrorism that's aimed at killing innocent civilians here and elsewhere around the world. I just want better rules that adhere to international rule of law principles in terms of how we're going to fight and respond to that war. Thank you.
Thank you especially to Michael Talia, to Amy Evans, to Jordan Kilby, to Dan Browder, to Lori Sandman, to Summer Nelson, all the student groups, to Scott Crichton and the ACLU for sponsoring this conference. Thank you.